Good morning, everybody. Good morning. Glad to be here. And I'm just going to follow up on Carrie. I'm an attorney here in town. My name's Greg Taylor, and we're going to talk about estate planning this morning. And just as a follow up to what Carrie said about starting the conversation, we're going to talk about just a little bit of the basic facts about what happens when you're gone, how to think about how you want that transfer of assets to happen to the people that you care about, okay? So that's what we're here to talk about today. And I guess that's probably the first thing we think about. We're talking about being prepared for transfer of your worldly possessions, right? More important than that is being prepared for your your eternal soul. And I just want to say this morning that we're all alive. We have the opportunity to live for Jesus. We have the opportunity to recognize Him as our Creator, and that's what I'm going to do this morning. Is think about this is for our earthly stuff. It's not nearly as important as our soul, and I just wanted to say that as a follow up to what Carrie said. So we do have stuff, okay? Everybody has accumulated assets. Whether you have a bank account, you've got your house, you've got whatever it is that you've got, and you also have people that you care about. You have family members, friends. You've got maybe it's institutions. You've got Murray State. You've got the church. You've got things that you would like to benefit with your assets once you're gone. So all of your assets fall into either a couple different categories. Okay. First category is Okay. Thank you, Mark. Okay. Can you hear me better now? Thanks, y'all. Okay, so there's two different categories that everything falls into. First category is stuff like retirement accounts. You've got life insurance. You've got probably your investment accounts, things that are going to transfer. You've got a contract, okay, that says when I pass away, these assets are going to go to whoever I say they are going to. Because is everybody familiar with that? You got a life insurance policy, you got beneficiaries, okay? You can do that with your house. You can put your house in survivorship to where your kids would get that when you're gone. You can do that with your bank accounts, with anything you can put payable on death. So that's kind of the first category, okay? So we call those non-probate assets. So you got those non-probate assets that are going to go automatically. Second category is anything you own individually that doesn't transfer automatically. So most of the time, a lot of times what happens is you have a husband and wife, and then one of them passes away. Well, the house automatically passes to the surviving spouse. And then that when mom or dad, the second one, passes away, then that house has to go through probate, okay? The bank account has to go through probate. All those assets have to be gathered together and transferred to somebody, okay? So for those probate assets that have to be transferred, then there falls into two categories on that as well. Okay, there's one is they call testate. So that means that you had a will. Okay, your will says that you desire your assets to go to certain individuals or whatever. If you don't have a will, we call that intestate, and then the state basically steps in and says there's a descent and distribution statute that says it's going to pass to your children, your spouse, whatever. Typically, if you're married with children, it would go half to your spouse and then the remainder to your kids. Now, half to your spouse and the remainder to the kids is not normally what people want. Usually, if you're married, you want it to go to your spouse so that they have everything you need. So that's a big reason to have a will right there. Additionally, will can set guardians for kids or anybody that you're in custody of, minor children. So when if you do have a will, or even if you don't, and you go through probate, let me just explain how that process works a little bit, okay? So you would make a petition to the court to have someone appointed as administrator or executor, and then that person would kind of gather up all your assets that have to be transferred, and then notify any creditors to make a claim against your estate, and then transfer those assets to the proper parties, okay? So if there's an administrator, it's going to go to the people that the state says it's going to go to. If there's an executor that you've named, it's going to go to whoever you've said it should go to, okay? That's a process that you can do on your own. It's fairly, I would say that unless it's a very simple estate, most of you would not want to have to do that on your own. You usually would hire an attorney to do it. It's at least a 6-month process. Many times it goes on for a year or longer. And then what happens is we would assist your heirs with, filing all the proper paperwork, giving notice, making sure that everything is done correctly over that period of time. Typical cost for that would be in $2,000 to $3,000 for a normal small estate. Okay, so you've got some time that's involved in there. You've got some complexity. One of the things that we like to do in thinking about estate planning is how do we minimize the burden on our heirs, on our kids, grandkids, whoever's going to be taking care of things when we're gone. So the number one step is having a will. Okay, that's the most common thing. In some instances, it's appropriate for people to go take another step in minimizing that and having what we call a trust. Okay, so I'm going to talk about trust for a second. A trust is a non-probate asset. So remember, we got the two buckets. The first is probate asset. Second is non-probate. So a trust is a non-probate. All the property you put in there would be non-probate because it passes automatically under the terms of the trust. Okay, so if you have common scenario, okay, if you have a home in Kentucky and a home in land or Tennessee or land in Florida, whatever, if you've got property in multiple states, you would have to go through your estate would have to be probated in both states. So in other words, you'd have to go through a probate process here and also in whatever other state that you've got. Okay, and so that can be quite costly, time consuming, whatever. So if that's a common thing. There's also other scenarios in which a trust would be beneficial. But the main reason that we would do that is a trust does not have to go through probate. You put your assets in the trust, you identify trustees, yourself for your lifetime, and then maybe your kids or another trusted individual when you're gone. And then those assets transfer automatically, just like a life insurance policy or whatever. It goes, and then the trustee follows your wishes and transfers it to the proper parties when you're gone. Okay, so a trust is more complicated during your lifetime because you have to actually come in and see an attorney, draft it all up, do accompanying wills and powers of attorney and everything, so that it's all one package. Then what happens is you have to continue to contribute your property to the trust because essentially everything you own would be tied up in that trust. Does that make sense? It's because if you do that, then you don't have to go through probate at all. Okay, so that's an alternative as well. And that I mentioned the trust because for many people that is going to minimize estate costs. Okay, it's also going to simplify things for the children. Okay, just because you basically come in to see me or another attorney, deal with some paperwork, and it's done far quicker than 6 months and far less costly when you're gone. Okay, so that's kind of wills and trusts in a nutshell. I just want to talk about a couple other things real quick. Powers of attorney, okay, and Carrie mentioned those. Powers of attorney are essential. They're essential for me. They're essential for all of you, for anyone who has assets, because you never can tell what might happen when you may not be able to take care of your affairs or have to make healthcare decisions. So you can have a power of attorney for healthcare. You can also have a power of attorney for property. And those people that you appoint as your power of attorney are going to be able to do whatever you authorize them to do. So in general, a general power of attorney says, hey, you can do anything I can do. So if I can buy property, you can buy property. If I can do investments, you can do investments, okay? That's a general power of attorney. So you also have limited powers of attorney where you can appoint people as powers of attorney to do limited things for you, okay? And so there's healthcare power of attorney that says if I'm ever incapacitated, I want this person to make all my healthcare decisions. There's a living will that then comes in at the end of life, and it says if I'm not able to survive on my own and am in a terminal condition, just want to be allowed to die naturally. Okay, that's a living will, and the hospital is very familiar with those. And so all of those are estate planning tools, okay? So and you need to know how those work and think about how you want things to happen for you. So in other words, what's the scenarios? Okay, I'm in a car wreck or something, unable to make decisions for myself, handle things for myself. Who do I want to be doing that? Okay, when I'm gone, how do I want the assets to be transferred? Who do I want them to go to? And you think about those things, you come in, you talk to me or another attorney, we can get everything written the way that you want it. It does need to be done in conjunction with your family. I always recommend that if we ever come in and do estate planning, and that obviously all the beneficiaries should know what's going on. What's not good is where we do an estate plan and then we're probating the will, and somebody comes up and says, "Well, I didn't know Dad was going to do that." Right? That's problematic. It doesn't lead to family harmony down the road. Okay, so we're doing all this to just ensure an orderly transition. Nobody likes to contemplate, death or moving on. But for my clients, I can tell you that once it's done, it's a burden off of you, because you know that you have a plan, and you know that your family is going to understand what's going on and be able to be taken care of. Okay. I think that's all I've got this morning. I'm so glad I could come see with you guys, and I'll be over here if you got any questions or whatever. Oh, you have a question? Yeah. No expiration date on wills, as long as the expiration would be when you make a new will. So in other words, you actually there is a few things that you can do. You can tear up your will, you can burn it, you can destroy it, or you can make a new will. Okay. Do we have time for a couple more questions, or no? We do? Do we have other questions? I'm happy to. Yes.
Yes, me and my wife have one daughter.
Okay.
If we don't have a will, we get killed out of the car. Our estate automatically go to her.
It would go to her, but if you only pass away, it would go to her and half to your daughter and half to your wife, and then without a will. And then what happens in that situation is then your daughter has to then come in and disclaim her part and gift it back to your wife. You see what I'm saying? We see that done a lot where people don't do the wills. You got to get the kids to come in and say, "Well, I don't want my 1/6 interest in mom and dad's house. I want it to go." You see what I'm saying? So having the will avoids all that. Yes, sir.
If you have a will and everybody's been designated, does it have to go to 6 months?
Yes, it does. Yeah, your will is always going to be probated, and it's going to take that time period, because that's the 6 months is the time period in which creditors can come forward and file a claim. Unfortunately, if you have less than $15,000 of assets and you don't have any real estate, there's a shorter thing that they can do. So if you have let's say all you have is a bank account and you don't own a vehicle or a house or anything, you can do what we call dispense with administration. That can get done pretty much immediately. But if you have any assets really that need to transfer, the court does that so that it gives creditors time to come forward and say, "Well, he owed me some money." Does that make sense? It's a 6-month period that we can't get around. Okay.
Who runs the ad in the paper?
Okay, so he's asked who runs the ad in the paper. The court does. So we pay a filing fee to the court, and they actually run the ad in the paper for us. So they notify some creditors. Now we actually also are required as executor to give specific notice to known creditors. So let's say your daughter is the executor or whatever, and she knows that you had some hospital bills out there. Well, she has to give a notice to the hospital, send them a letter saying, "Hey, we've opened up the estate. You want to come forward and make a claim, here's how to do it." Okay, and so give notice on that end. Okay. Yeah. Yes.
For the trust, what is the dollar amount that should be included in the trust?
Okay, so I'm not sure if I'm following. So she asked, what is the dollar level that should be included in the trust identification of assets? So there's no real dollar number that say, oh, well, if you have more than $200,000, you should have a trust, or X number of dollars, but it would all your assets would come into the trust.
What is classified as assets? I mean, if I have stolen silver from my grandparents' house.
Right. So yes, so all those assets, so non-titled assets, okay, would get transferred in the trust via what we call, it's a global funding directive. And a global funding directive says, hey, we've created this trust. We intend for all of our assets to go into it, despite the fact that there's no title to this. We are saying that all of our assets go in there. So we do cover those bases on the trust. So we make sure that if you have vehicles that they're transferred in the trust. We make sure that we do a deed for your house. We do directives to your stockbrokers and bankers or whatever to make sure that those assets get transferred in the trust so that there's nothing left out. Okay. So that's kind of how that works. Yes, sir.
You have a POD in your bank account, but it still has to go through probate.
No, sir. That's a great question. He says, if you have a payable on death on your bank account, will it have to go through probate? No, because payable on death transfers automatically. That's the function on that. So as an alternative to a trust, if you only have a few assets like that, and you want to just put them all, we can come in and you can make sure that you get that done. I've had several people come in thinking they wanted a trust, and that was just simpler. Okay, you just do payable on death on your bank account. You put your car in jointly with you and one of your children or something like that, if that's feasible. So all those options are available as well. Yes, ma'am.
On the POD,
Okay.
the individual you want this designated, do they have to be at the bank to sign anything?
Typically, with the payable on death, no. That the bank now that and they're probably maybe different banks would have different regulations, but you would designate who you want. When you're gone, they would bring in the death certificate to the bank and say, this person is now deceased, I'm payable on death. But they would get a notice. You'd have to notify them, okay, that they're, whoever you're appointing is payable on death, you would have to notify them. But I don't think they'd have to come in and sign on the front end, I don't think. You see what I'm saying? Okay, maybe one or two more, yep.
What about if you have investments somewhere that have POD?
Yes, investments, anything that's payable on death. The investments are commonly, you have beneficiaries that after you pass away. Most investment accounts, you're going to have designated someone, so it's not going to have to go through probate, okay?
What about and or on bank accounts?
And or, now that's a banking question. I think jointly, most of the time it would say and, you and a child or something like that. So if you've got it titled as jointly, it definitely transfers automatically, okay? Now, or on your car title, I do know also transfers automatically as well, okay? Does that make sense? Are we good? Okay. One more from Mr. Imes.
You might explain the difference between a codicil to a will.
Okay.
And a new will.
Sure, and that's a good point. So at any point, so people always ask this. Okay, now we've done our will. Do I go file this up at the clerk's office or something? Right? No, you don't. You don't ever file your will until you're deceased, because you can always make a new will. So you could come see me on Monday, make a new will on Tuesday. Okay. Now a codicil to a will is just an amendment that says, I think everything in this will is good, but I have one or two little things that I want to change, and so I'm just going to leave everything as it is, except for these one or two things. I'm going to make an amendment. So that's a codicil. So you can come in and do that at any time after you make your will. If you change your mind, we can do that. Typically, I've done very few codicils, because usually when people want to come in and they know they want to change their will, they just want to do a whole new one. Okay, but that can be done if you have a long, complex will and you want to just change a couple line items, change a couple beneficiaries, something like that. We definitely can do that. Okay, so that's the true of any of your estate planning documents. Just because you appoint somebody as power of attorney doesn't mean you can't go back and change that. Anything is changeable as long as you are competent and alive. Okay. When you pass away, everything's done. Okay, y'all. Thank you so much. I'll be here later, and you can come see me and ask questions. And I do have some. I just want to point this out. I brought some will checklists. So if you haven't thought about how you would go about doing a will, I've got several here. And if I run out, I will be happy to get you some more if you just give me your information later. Okay. Thank you all.